Hi, I'm going to keep talking about the rules of evidence. We're going to go into um, the residual exception next, um, and we're going to talk about the Dallas County v. Commercial Union Assurance Corporation case on page 723. If you're following along, um, Professor Younger, one of the writers of this book, considered the Dallas County case to be the best opinion on hearsay ever written, and certainly it's the most practical. This case arose when the Dallas County Courthouse was severely damaged after its clock tower collapsed onto the building. Dallas County sought reimbursement from its insurance carrier, alleging that lightning struck the tower, causing it to collapse. As proof of the lightning, the county produced some char debris from the tower itself. The insurance company denied liability, maintaining that the lightning had not caused the tower to collapse. Indeed, the insurance company had quite a different explanation for the collapse. The defense maintained that a fire, which had occurred many years before the policy was issued, ultimately caused the tower's collapse. To prove that point, the insurer introduced into evidence the Morning Times of Selma dated June 9, 1901, which reported that a fire had occurred in the county courthouse. The problem with the newspaper article was that it was hearsay if offered to prove the content set forth in the article. In other words, it was hearsay if it was being offered to prove the matter being described in the article, that a fire occurred at the county courthouse on a particular date, the truth of the matter asserted. Was there an exception? Notice the reasoning here that Judge Wisdom employed. He essentially said that we should apply a common sense approach. Common sense means that we should look to the best available evidence. In this case, he concluded that the newspaper was probably the best available evidence of a fire having occurred in 1901. From a necessity standpoint, this is the only evidence available to prove this point. Furthermore, it is probably reliable. A newspaper is not likely to report a fire in a well-known county building unless such a fire actually occurred. Judge Wisdom then suggested that the rule against hearsay should not be applied in such a rigid, mechanical fashion that on occasion it should work in a manner akin to the best evidence rule. In other words, insist upon a non-hearsay proof if it's available, but if it's not, admit the hearsay if it would be otherwise reliable. Now, Judge Wisdom could have decided this case fell within the so-called ancient document exception, which the federal rules later codified in Rule 803.16. But he argues instead that we ought to apply a flexible approach based upon a great need and probable reliability. In conclusion, there ought to be a fail-safe catch-all exception of the hearsay rule, which applies when no other exception is available. The Federal Rules of Evidence eventually adopted Wisdom's approach, originally in the Rules 803.24 and Rule 804b5, and more recently recodified in Rule 807. 807 formally establishes the residual exception Judge Wisdom contemplated and imposed certain conditions for the admissibility under these circumstances. The point is that even if hearsay does not fit within any categorical or hearsay exception, if it meets certain requirements, it may still be admitted under this residual provision. To be admissible under the residual exception, a statement must have some circumstantial guarantee of trustworthiness equivalent to all of the other hearsay exceptions. In other words, the proffered hearsay must be at least as reliable as the other exceptions set forth in Rule 804. Second, you must be able to establish that the residual hearsay is necessary because it is the most probative evidence available on point. Third, the court must find that the admissibility is in the interest of justice. And finally, the opponent must be given notice of one's intent to rely upon this rather novel hearsay exception. If we jump over to the Huff case on page 728, Huff v. White Motor Corporation in 1979. This was a products liability action of the Seventh Circuit, and it discussed the most probative evidence available, on point requirement of Rule 807. The action was one for wrongful death brought by the survivor of a crash in which the victim's truck's gas tank ruptured and caught fire allegedly because of the defective design of the fuel system. At trial, the defendant manufacturer offered evidence of the decedent's hospital bed statement, which proved that the decedent's clothes were aflame before the crash. Decedent was a smoker. The court affirmed the admission of the decedent's statement as residual hearsay on the theory that the statement is the only direct evidence of the cause of death and that direct evidence is superior, i.e. more probative, than expert accident reconstruction evidence and other circumstantial evidence. In the United States v. Bailey case on page 734, this case represented the correct view of Rule 807 in the professors that wrote this book, in their viewpoint. The court rejects corroboration as a guarantor of reliability, a principle affirmed by the U.S. Supreme Court case in Idaho v. Wright, on the ground that 1. The circumstances surrounding the making of the statements are the appropriate means of trustworthiness as they are as are for the enumerated exceptions, and 2. The corroboration as a measure of trustworthiness is inconsistent with the requirement that the residual hearsay must be necessary because it is the most probative evidence available. In addition, it finds that the proffered hearsay is unreliable because, inter alia, it was made during the self-serving plea negotiations. The residual exceptions to the federal hearsay rule are, the two exceptions in search of a rule. I'm going to jump to 740. That's another guy that, it's the Sonnenschein near misses thing. Although Professor Sonnenschein argues against the admission of near-miss hearsay via Rule 807, the weight of Federal Circuit Court authority admits near misses. Though near misses are by definition less reliable than enumerated exceptions, the foundations for which they lack, federal courts often admit such hearsay despite the failure to identify any circumstantial factors which bring the near-miss evidence up to the equivalency of trustworthiness with the enumerated exceptions. Indeed, it could be argued that the federal appellate mistreatment of Rule 807 has to some extent realized Judge Weinstein's position during the federal rules codification process that hearsay should be admissible in the discretion of the trial judge. If we jump to 747, I'm going to start talking about attacking and supporting the credibility of the declarant. Actually, this is about impeaching the hearsay declarant. This Sonnenschein article illustrates the rationale for Rule 806, which is attacking and supporting the credibility of the declarant. Without Rule 806, which every state has adopted as a rule or a matter of common law, the rules would create an incentive to avoid calling live witnesses. And then, okay, we're going to jump to Idaho v. Wright after this, I believe. I'm going to cut it off right now and then talk about, because what we're going to go into next is hearsay and the constitutional confrontation rights, and we're going to go look at the Idaho v. Wright case on page 749. I'll do that next. I think this video is running a little long. Yeah, it's right at 9 minutes. So I'm going to upload this and then we'll move on. Okay.